Welcome back to Just Liberty, where liberty and justice meet, or sometimes justice and liberty meet. I'm not quite sure. I'm Alan Ronak, president of the Church State Council, and here with me is Bettina Krause, the amazing editor of Liberty Magazine, the best and oldest magazine devoted to religious liberty. We are trying to take back religious liberty from the political extremes. And today we have a guest talking about one of three religion cases before the Supreme Court, a case involving potentially a Catholic charter school in the state of Oklahoma. And this would be the first, if it's approved, the first religious charter school ever to be funded here in the United States. So, Bettina, why don't you introduce our guest?
I'm delighted that we have with us today attorney Todd McFarland, who is Deputy General Counsel for the General Conference of Seventh-day Adventists, and who is, and this is his most important role, he is the legal advisor for Liberty Magazine. I'm sure, Todd, that comes right up the top of your CV, right?
It is one of my more cherished roles. That is true.
Thank you. I appreciate that. Well, we're here to talk about a case which is very much in the news at present. It's about a charter school in Oklahoma that is a Roman Catholic charter school. Todd, why don't you start us out by setting up the case? What are we talking about here when we talk about St. Isidore Roman Catholic Charter School in Oklahoma?
Sure. So, St. Isidore and the Educational Association with it applied to become a charter school in the state of Oklahoma. Oklahoma, like a lot of states, has a program by which private organizations can apply to become and provide schooling is part of the educational system that the state runs. So applied for it. It met all the academic criteria, but it was and is a religiously affiliated institution, and not just religiously affiliated in name, but religiously affiliated in what it's going to do, and it wants to indoctrinate Catholic beliefs into the students and otherwise be a religious school. And so on that basis, it was denied a charter school grant or license, and therefore it brought a suit claiming the state of Oklahoma had discriminated against it because it turned it down because of its religious nature. And I don't think there's any question that's why it was turned down. So there isn't really an issue here of, oh, well, you didn't have the right number of teachers or you didn't have X, Y, or Z. I should also say this was going to be a virtual school.
Well, I find that part of it very curious because some years ago, when the issue of vouchers was before the Supreme Court, and the court still cared about the distinction between pervasively sectarian schools and schools that were not so religious, I had submitted a brief and pointed out that um, the way that faith is transmitted in religious schools is not just by teaching the beliefs, but it's in the community. It's kind of, in the air that you breathe as part of a faith community. Court didn't care, uh, but the idea that you would have a Catholic school that would want to be teaching, I think remotely, you certainly lose that element of community. Hard to create that same sense of community in that way, right?
Well, again, I don't think it's for the U.S. Supreme Court to decide, make that kind of determination, right? Like that is for them to do. They felt like they could deliver that. There's a lot of Christian, online schools out there and virtual schools. There's also brick and mortar schools. There are pluses and minuses to both, but again, I don't think that's a legal issue before the court, nor do I think it's one that courts should delve into. Whether or not, well, you say you want to have a religious community, but is this really the right way to do that? I think that's up to the religious institution to decide.
No, fair
And
enough.
so and the issue really that is capturing most attention, especially in the media, is the issue of state funding for the religious mission of the school. There is a decades-long tradition or understanding that the Establishment Clause would preclude that type of funding. that has been changing over recent years. Todd, help us understand the specific legal issues that are presented to the Supreme Court with this case. Now, and also maybe talk about the Oklahoma State Supreme Court's decision in this case.
Sure. So Oklahoma's the Supreme Court decided that this violated both the primarily the Oklahoma Constitution. And Oklahoma Constitution has a provision that says that no government money can go to essentially a religious organization. And they said this violated that. They also said that this was a public school, and we're going to talk about this in more depth, I think, but that this was essentially a state actor. And so they said, listen, our Constitution prohibits this, and also it would violate the U.S. Constitution, and they cited to some other provisions in the Oklahoma state law. At the Supreme Court, though, none of that really matters, right? It's not that it's not that it's irrelevant, but a state can't call something and just be the end of it. In other words, you need to be able to look behind it and see if that really is what's going on. And that's what the plaintiffs in this case are challenging. They're saying, listen, well, first of all, they're saying that the Oklahoma constitutional provision is itself unconstitutional of the U.S. Constitution. So despite the Oklahoma Supreme Court's protestations to otherwise, they're claiming this is something called the Blaine Amendment or a baby Blaine Amendment, which was this amendment that was in the early 20th century that was very anti-Catholic. The Oklahoma Supreme Court distinguished that, and said it's not. But again, that's what the plaintiffs are claiming. And it does have a very broad restriction on religious organizations getting any government funding. So what the U.S. Supreme Court will be looking at in the two issues it's going to be asking is, first of all, and this is a term of art, is this charter school going to be a state actor? And if it answers that in the affirmative, then it really is the end of the case. This case, I feel like it has been misportrayed in the media as far as what the issue is. Everyone's like, oh, this is an Establishment Clause case, and this is about the depth of the Establishment Clause, that the Supreme Court rules in favor of the school. But there's no question that if this school were a public school, like the state of Oklahoma says it is, or should say the Oklahoma Supreme Court says it is, then it violates the Establishment Clause. So there really is no Establishment Clause per se jurisprudence to be made here. Where the Establishment Clause does get involved more is in this: if it's not a state actor, then the second question is, well, can the state of Oklahoma distinguish between religious and non-religious schools and who it gives the benefits to? And what the plaintiffs in this case are making argument, there was a similar case, I shouldn't say similar, there was a case a couple of years ago called Carson versus Macon. In that particular case, the state of Maine, because it's a rural state, because it doesn't have public schools everywhere, said, listen, for certain parts of the state, it is easier and cheaper for us to just pay the full tuition for a student to go to any private school that they choose, and we'll pay that. But that's any private school they choose, except if it's a religious school. So you could be a secular school, and so it was a clear distinction there between the two. And the U.S. Supreme Court said that's discrimination. And so there's follow-up litigation related to that based on what the state of Maine did later. But then that is the second question is, well, can the state still discriminate against religious educational institutions, even if they would constitutionally be allowed to do this? So those are the two issues before the court.
So let me kind of back up to perhaps a basic question here. Who gets to decide whether the school is a state actor or not? It sounds like the Oklahoma Supreme Court said, under our system of education and how we do things, this is a state actor and it can't be religious. The state gets to decide, who gets to act on behalf of the state as a public school.
So, yeah. So that is a federal question. It is a federal constitutional question, state actor and doctrine, which, by the way, implicates a whole range of things, right? Like if you're a state actor, that just brings in a whole lot of case law and a whole lot of responsibilities, and the whole weight of the Constitution restricts you, etc. And it is absolutely not a state question. It is a federal question. And back in the days, we absolutely, we're okay with that. So, for instance, I'll take an example of the Alabama High School Athletic Association, an entity I've sued before. Like it is in one sense a private entity. So, in other words, the employees there are not state employees. It is not funded directly by the state. The state legislature, the state governor, does not determine, what it does. But it was found to be a state actor, back in the civil rights area when they wouldn't let any of the black schools in. No one complained then. No one said then, the state of Alabama gets to decide who's a state actor. No, no. It is and always has been a federal question. And I would say on this particular point, even the defendants, right, the school and ACLU and those that are representing them, they don't disagree with that. They know that whether or not you're a state actor or not has to be something that the feds will decide. You have to be able to look behind what the state says it is. So it's, again, the state of Oklahoma and the Oklahoma courts get to decide that through their system, but ultimately we are the Supreme Court. U.S. Supreme Court is the one that decides that.
And if you would just expand for a minute on kind of the broader significance of why it matters. I mean, one thing that, you're bringing to mind for me is if you're a state actor, then you can't violate people's freedom of speech, for example.
Right. Yeah, you can't violate their freedom of speech. You can't violate their religious rights. You're subject to 1983, this law that gives you liability. All of the provisions of the U.S. Constitution apply to you. And on one hand, you talk about if for a private organization, you actually do want to be able to, quote, violate people's religious beliefs. You want to be able to violate their speech rights. It's not that you're violating them, they just don't have it in that context, right? The restrictions that are on the federal government when it comes to religion and speech, if that applied to private organizations, it would destroy them, right? I mean, a religious organization by its nature has to discriminate on the basis of religion. I mean, the Catholic Church has to hire Catholic priests, the Adventist Church has to hire Adventist pastors, etc. And even on speech rights, an organization has the right to say what we're going to talk about and what we're not. And so, importing those into a private organization, and this is one of the concerns that I have, it really destroys that organization's private character. In fact, it makes it really into a public entity.
I want to change tack just slightly, and we'll come back to this case again. But Todd, can you explain to us the Seventh-day Adventist Church's stance on issues of separation of church and state and how we have interacted in some of these legal cases in the past, especially at the Supreme Court level? I sort of want to understand from a legal perspective how the Adventist Church tends to frame issues of the state funding religion and religious enterprises.
Well, so there's about 5 different questions in there, but sort of let me talk about the Establishment Clause and the free exercise. So the church has historically and continues to advocate for a stronger separation between government and religion. And that is a stance that we have had since our founding, since, the 1860s and well into the early 20th century, and we continue to have. The challenge has become, in a modern era, what does that mean? What does that look like? So, for instance, we started healthcare systems and hospitals, well before the 1960s in Medicare and Medicaid. But when the federal government got into the healthcare business and now dominates that with billions and tens of billions of dollars each year, you cannot run a hospital system and not interact with federal Medicare and Medicaid programs, right? So, yes, back when we founded our hospitals, the idea of the government getting involved would have been anthem. Now, if you want to run a healthcare system, you can have a full separation between government and there because, you just can't run it without, having Medicare and Medicaid patients. Same thing with higher education. Our higher educational institutions started well before federal student loans, well before accreditation, before those. Now you have those programs, and because the federal government has come in with its financing, to be in the space, to be recognized, you have to interact with the federal government in some way. You also see the federal government regulating entities a lot more than they were, back when we were founded. It's everything from Fair Labor Standards Act to occupational safety and health to, fire codes and all that kind of stuff. And generally speaking, and I do mean very generally, those may or may not implicate, a religious belief, but they certainly been misused by government to restrict religious practice, and they can certainly have a negative effect there. So we do believe in a strong separation. The separation that existed when we were founded just is not possible in a modern era, just because of the expansion of government in the different parts it is in our lives. Uh, there's also the other side. It seems like both sides only want to talk about one half of the First Amendment, or the religion clause of the First Amendment, either the free exercise or the Establishment Clause. And you saw a time period of the Supreme Court, especially back in the 1970s, in which everything was an Establishment Clause violation, but yet there was never a free exercise violation. Nowadays, we do see more free exercise violations and Establishment Clause violations, and different sets of people are now upset about that. The Adventist Church has tried to have a middle approach that balances the two of those, but that can be difficult depending on the situation you're talking about.
Well, my primary rule of thumb is that both clauses work together to protect religious freedom. And if you are somehow uh, analyzing them to be in conflict, you're probably on the wrong track. My basic overarching
Yeah,
philosophy
but
here.
I think you should let the Supreme Court know. Maybe that would help them in their decision.
yeah. Well,
Well,
but
I
the
can't
problem
anymore.
is,
Only Todd can.
no, 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 no. First of all, and maybe we should talk about the structure that we have on this, right? And so the structure the church has is there is, Office of General Counsel does take the lead in what we're going to say before the U.S. Supreme Court and other, amicus briefs, and I'll explain what that is in a second. But there's a whole committee, chaired by vice presidents from the GC and the NAD, with representation that looks at these issues and considers them. I would also say the amicus committee, generally speaking, is simply making administrative decisions to sign on briefs on well-established church principles that we've had here, and isn't really, the vast majority of the cases, we're not cutting new ground, right? But yeah, there are times that come up, and I think Carson versus Macon is a perfect example of that, right? Like, the government has decided to pay people's tuition to a private school, so there is no public school for them to send them to. So then parents are said, well, I can either send them to a secular school, essentially, but why should I not be able to choose to send them to a religious school if that's what the parents want? And if the government's already decided they're going to pay for private schooling, then should they be able to discriminate against religious institutions? And parents do have the right to raise their kids. They also have a constitutional right to send their kids to the school of their choice. What they don't normally have is the right to make the government pay for it. But when the government does decide to pay for it, does the government get to decide to discriminate against, religious schools? And the Supreme Court said no, it doesn't. But there were a lot, the same people who are opposing, St. Isidore becoming a charter school, who felt that the government should be able to exclude religious schools.
So let me go here, Todd. One of the basic principles of our Adventist Church's policy on these issues has been that we should not become dependent on government funding income streams. So let's take a look at, for example, this Oklahoma Roman Catholic charter school. Right now, if it's approved, it's operating in what we would call a red state environment that is
Yeah, but
sympathetic to the traditional values of a Catholic school. But what would happen in a few years if the politics and the culture in Oklahoma shifted and it became a blue state and it became much more friendly, say, to LGBT interests and concerns, and it began to mandate as in its curriculum, a curriculum like the one at issue in Montgomery County, Maryland, that is very supportive of LGBTQ values and very if not outright hostile, certainly not inclusive of people of faith. What happens when you have a school that's getting money, and
correct.
yet the state insists on, we have certain curriculum guidelines and curriculum values that we insist every school getting money should um, should follow.
Well, I think that's part of the challenge, and that also intersects with the litigation that's going on in Maine post Carson versus Macon, right? And that is, what kind of strings can you put on there? And no one really debates that they can set, what I would call true educational curriculums, right? Like, you got to teach a math course, you got to teach a history course, you got to teach English, you got to teach social studies, you got to teach whatever, and you've got to meet these certain, uh, you know, educational requirements. Where it becomes a problem is exactly what you're talking about on the air, is when you go beyond that and you try going into ideological issues and trying to enforce that. And I would say what the plaintiffs here would say is that the government can't do that. It has to allow these religious institutions to be religious. They can insist that they cover certain subjects and meet certain testing criteria, but the actual content of it is up to them. And quite frankly, that's really what we already still have, right? Like, even the private schools that receive no government funding, they're still not free of government interference. Like, you still have to register, you still have to get some form of accreditation, you still have to get some kind of licensing. And so it's not like the state of Oklahoma or any state is going to completely get out of telling a religious school what to do, even if it gives it zero funding. In fact, to some extent, and we've seen this in other Supreme Court cases, the funding issue is a misnomer. Because, what if the state of Oklahoma decides, or Montgomery County, Maryland says, you know what, we're just going to directly impose this curriculum requirement on LGBT issues, like moot on all schools. Forget the funding issue. If you're going to teach here, just like you've got to teach 2 + 2 = 4, you've got to teach that a same-sex marriage is an equal expression of love as a heterosexual marriage and is equivalent in all ways. And, I would hope the Supreme Court would say that they can't put that requirement in, but the arguments that are being made in St. Isidore and, in that charter school would, generally speaking, allow the government to do that. Because what the Supreme Court has said repeatedly is the difference between what the court can make as a funding condition and what the state can make as a funding condition and they can just directly require is very narrow. So in other words, if they can do it as a funding condition, they can probably just require it directly.
Now, there's going to be a lot of people listening to this podcast, Todd, who don't hold law degrees. Surprise, surprise.
Yeah.
And
Those lucky souls. I think everyone on this call has a law degree.
they're more pure than us.
Yes.
Is it a degree or a penalty?
Yes.
And many of the issues that we're talking about, they're just complex. They're complex whether you hold a law degree or not.
Yeah.
And so I want to sort of back up to like the 10,000-foot level again
Mhm.
and go back to this case that we're talking about. The fact that the Adventist Church, which has for, more than 150 years stood for this principle of meaningful, however that looks within the current context, but meaningful church-state separation for a variety of reasons. We've stood for that principle. The fact that we have not engaged in this particular case, what are we saying with that? Is that an expression of support for the idea of a fully state-funded Roman Catholic school?
So no, it isn't. It's a statement that the Establishment Clause, for the most part, is not on the agenda. And the reason I say that is that if the school is a state actor, then it violates the Establishment Clause. If the petitioners in this case, if St. Isidore was arguing, oh no, we're a state actor, but this doesn't violate the Establishment Clause, first of all, it would be a pretty over-the-top argument, even that with no matter who's on the Supreme Court. And second, we would, I mean, again, I'm not the committee, but we would almost certainly file a brief that says, no, 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 if this is a state actor. But where the question becomes is, just because the government gives an entity money to conduct a service doesn't make them a state actor. And we see this in a whole lot of situations, right? So for instance, before USAID got shut down or had, the government would give grants to all kinds of religious organizations to conduct their service, conduct their business, but they were not state actors. They were Adventist, employees. They employed Seventh-day Adventists in their headquarters. They did a whole lot of things if they were a government actor they couldn't do. Same thing, Alan made reference to vouchers before, right? We talk about direct versus indirect aid, but, religious schools have been getting money from the government in a whole host of ways, for a very long time, and we haven't said that violates the Establishment Clause. So, for instance, farm, right, free and reduced meals. So the government, has an interest in paying, for kids who come from, low income households, and paying for meals. Would it violate the Establishment Clause for them to pay for that meal in a religious school as opposed to a public school? So there's all these different funding streams. I mean, I went to one of our Adventist higher educational institutions, Southern Adventist University. I could not have done that, given my parents' background and so forth, economically, could not have done that except for federal student loan and Pell Grant programs. And if Adventist schools have been excluded from that, I would have had to gone to a state higher educational institution. So, now it is true that charter schools, this would be the first sort of religious charter school nationwide. But the reason, that we did not weigh in on this directly was because on the Establishment Clause, the Direct Establishment Clause, the question is it a state actor? Is it not a state actor? Once you determine that, you determine most Establishment Clause questions. Then the second question, and the second question about, well, can the state ban this even if it doesn't violate the Establishment Clause? I think that's a secondary issue, and we don't join every case, right?
All right. So there's two issues here. You said if the court decides this is not a state actor, well, you said
Mhm.
if it decides it is a state actor, then the Establishment Clause issue is pretty obvious, and you think, uh, you
No,
know,
I don't think the other side agrees they lose.
okay. But the question is, what if the court says this is not a state actor? Then
Right.
isn't there plenty of wiggle room on both sides? The court could go either way on that.
Well, then the question becomes, if it isn't a state actor, then can the state of Oklahoma choose to exclude religious organizations under its, program, even though funding it wouldn't violate the Establishment Clause? Can they just simply, underneath their own constitution, prohibit doing this? And it creates a very challenging sort of discrimination problem, right? Like we talked about in Carson versus Maine. Because if they can exclude this particular religious organization from participating in the program, could they exclude Adventist Community Services if there is tornadoes in Oklahoma from coming in and setting up a warehouse and participating in relief because it is in fact religious organization. Now there is a difference there in that ACS and ADRA and so forth, they do not, as part of providing the services, evangelize or intent, like it's not a condition. They serve everyone who needs help. They don't make it a condition you be an Adventist or, here's your food and here's your Bible study, right? But still, where would the power of the state of Oklahoma or another state be? And again, not to put this in political terms, but there's a lot of blue states that would like to kick out basically all the religious organizations or force them to become essentially secular organizations, but religious in name only.
So I
Yeah.
know time is fleeting, but I guess the follow up is there's a lot of states that have these general prohibitions on funding of religion.
Right.
And some of those prohibitions are thought to have come from a very anti Catholic era,
Yep.
hence known as Blaine amendments after Senator Blaine and his efforts back in the latter part of the 1800s. But not all of these were motivated by anti Catholic bigotry. I don't know much about Oklahoma's provision, but if in fact it was simply motivated by views on separating church and state rather than bigotry as such, why wouldn't it be okay for Oklahoma to say, this is our tradition of separating church and state and respecting the independence of religious schools, that they're not going to be state funded, and it's not discrimination.
Well, so first of all, I mean, the word discrimination is kind of a term of art that usually what people mean when they say discrimination is unlawful or invidious or inappropriate discrimination, right? Like you're always making distinctions and differences. And, that just becomes the question of how much using taxpayer funded money can you exclude certain groups from participating in a program that's available to everyone else? Because the problem is these secular institutions, these secular schools, and not like these are some, religiously neutral place, right? They're going to be teaching values, they're going to be teaching things that touch on issues of religion and faith and morality. We see that we've now referenced, I think, like 3 or 4 times in the Mood case, right? Where, Montgomery County, Maryland is by its own terms trying to indoctrinate kids into its view of marriage and family. And those are issues that religion has been talking about a whole lot longer than Montgomery County's ever been around, or even the state of Maryland. And so, if these were sort of just neutral places where you came in, you learned some math, you learned how to do calculus, you learned how to do whatever, and you went home. But that's not what schools really have ever been about. And it's certainly not what schools are about today. So, you know, again, I want to be clear. We didn't come in on either side of this because there are, I think, compelling arguments going both ways. And it is, like you said, funding a religious school, it does seem, counterintuitive, but the reality is we do it in a bunch of other ways already with voucher programs and other state funding.
So this is going to be a topic of conversation that we pick up another time because clearly this issue is not going to go away. I guess we're going to get a decision, Todd, from the Supreme Court come June.
Yeah,
Is
I predict it will be on June, looking at the calendar here, on June 27th. That's the last Friday, or June 26th. That's the end of the term. And given when this is being argued, end of April, it will, in my view, it will come down either the last day or one of the last 2 or 3 days.
and whatever the decision is, it's going to give us a lot of fodder for further discussion.
I
So
don't think you're going to run out of things to talk about on this
Well,
podcast.
Todd, your law school gave you something that mine didn't, which is a crystal ball.
There you go. No, what they did give me was a calendar, and the fact that the Supreme Court,
It's
yeah, I
predictable
mean,
in
there's
this
always,
way.
by the way,
Yeah.
there is a possibility it could continue to the next term, but that would be extremely unlikely.
Right.
Okay, well, thanks again, Todd. Really good to talk with you. And I hope that our listeners now have a clearer grasp on some of the legal issues involved in what is going to be pretty much a blockbuster case, I imagine.
Yep.
So, Alan, what was running through my mind as we were talking about this issue with Todd was that when Liberty Magazine was first published, when it first rolled off the presses in 1906, that one of the central issues that we were talking about that we had an interest in was this issue of how far the state should support religious enterprises. And this issue of funding for religious enterprises was at the center of that discussion. But what Todd's analysis of this case really drove home for me is just how complex that issue has become. It's become increasingly difficult to frame it in those very broad black and white terms, which is not to say that the principle still doesn't stand and still shouldn't be supported, but it just means that we need to get comfortable, I guess, with nuance. What do you think?
Well, I guess for me, the notion that we don't fund religion, that religion depends upon God and upon the commitment of its members, we've lost that, right?
Yeah.
And,
Yes.
you know, I'll just say this. Years ago, when I was confronted by a colleague who reported that, our working class minority families could not afford religious school and their kids were not in church school. And we had a discussion about tithing because what we found out was if church members who, not just the ones on the books, but who were really committed and regularly attending, if we would faithfully support our own church and our own schools, even to the extent of, what the Bible, what we say we believe in terms of tithing, we could provide a scholarship for every kid who wanted a religious education. It's never been about money. It's always been about commitment. And what's always been in the back of my mind are the corporate sponsorships in the great cathedrals of Europe, where,
Huh.
because religion has waned when it has had government support, when the government pays the salaries of the clergy and it's post-Christian. And I fear that, you know, we're the embrace of the state is the death of spirituality. It's the death of the church. So
Yeah. As good old Ben Franklin put it, if religion is bad, it needs government support. If it's good, it'll stand on its own two legs. That is a very loose
it
paraphrase, you may have
is
noticed.
loose. Yeah, something about if God doesn't see fit to support it, then maybe it's a bad religion, right?
Yeah, exactly.
Okay. On that note,
On that note, until next time, this has been Just Liberty, and we are continuing on our project to extract religion from the political extremes. I'm Bettina Krause with Alan Reinach. And remember, eternal vigilance is the price of liberty.